Hello, welcome back to the English Law Channel. So, carrying on with the breach of duty and looking at falling below the standard of care which is required. So, Lord Macmillan in Glasgow Corporation and Muir, 1943, he made a point that I was making. Well, maybe I got it from him, saying that the reasonable man, that's just imponderable. Who's to say what's reasonable? And this is what his lordship had to say. It is still left to the judge to decide what, in the circumstances of the particular case, the reasonable man would have had in his contemplation. Here there's room for a diversity of view. What to one judge may seem far-fetched, may seem to another both natural and probable. End of quotation. So, a bit of the luck of the draw, really. With this judge, you'd win the case, and on the exactly same set of facts, you'd lose it with another judge. But such are the vagaries of human nature. So there is some diversity of view amongst the judiciary. And that's another point, is law and the judiciary relies on human beings who are flawed, who are variegated. And this is not something which can be proven to a scientific standard what's reasonable, what's not. So there's a bit of a wild card factor, just depends which judge you get. So, right, another thing is we're trying to reduce harm. However, this must be proportional to the danger, to the chance that something's going to happen. If it's a 1 in a million chance, you don't have to take serious steps to reduce it. Or if it's actually a 1 in 10 chance, the chance of harm is quite high, but the harm is very trifling, then you wouldn't have to take serious steps. If the chance of harm befalling you is high, then you're going to have to take serious steps. Or if the harm you're going to, especially if the harm is severe, that's the thing, it's the likelihood and the severity of the harm are the two factors we've got to take into account. I mean, if the harm is catching a cold, well, that's trifling. We all catch colds in the winter. That's not serious. If it's something which is deadly, well, that's different. So a defendant is not required to obviate all harm, even if it's foreseeable, because it's impossible to remove harm altogether. Right? We're born to die. So life is inherently hazardous. A defendant must do something if a reasonable person would do so in like circumstances. So in determining what precautions have to be taken in order to minimize the risk, certain guidelines should be followed. So, as I say, how likely is it that danger shall befall? Right, in Bolton and Stone, 1951, an appellate court case, the plaintiff was standing on a road which wasn't busy and hit by a cricket ball which had been hit from the defendant's cricket club. So it was unusual for balls to go out of the cricket ground. Only 6 times in the previous 28 years had they been hit out, and no injury had ever been sustained. So the risk of the accident was foreseeable. Everybody knows there's going to be a boundary once in a while in cricket. But the chances would occur was very, very small. I mean, how many cricket balls have been hit over 28 years? It would have to be in the tens of thousands, would it be the hundreds of thousands? And nobody been hit by a ball at all. So this is coming close to a 1 in a million chance. The House of Lords held the defendants were not liable because in these circumstances it was reasonable to disregard such a risk. It was just de minimis. In Miller and Jackson, 1977, a Queen's Bench case, the cricket balls were hit out 8 or 9 times per summer, and on several occasions they had damaged the claimant's property. The majority in the Court of Appeal held the risk of harm was so significant that the defendants were liable and negligent and indeed a nuisance. So even then there was no physical injury arising. So is the question of the likelihood of the harm occurring and foreseeability, because indeed it had happened repeatedly. So how serious is the likely injury to be if it does happen? In Paris against Stepney Borough Council, 1951, an appellate court case, it shows the obligations of a potential defendant will rise where the risk of the claimant is greater than the usual damage. In this case, the defendant knew the plaintiff was blind in one eye. Therefore, he was working in conditions where there was a risk of an eye injury, and the likelihood of the injury was trifling. So the defendants thought, well, we're not going to give him goggles, wouldn't give it to a normal person who had 2 working eyes. But the plaintiff lost his only good eye when a chip of metal entered that eye, and therefore he was totally blind. The House of Lords said the duty of employers is owed to each particular employee, and they were negligent in not giving goggles to the plaintiff. They wouldn't have to give it to the average employee because most employees have 2 working eyes. Anyway, so we also got to bear in mind how onerous or costly would it be to eliminate risk. If the risk is very small, not taking a precaution which is prohibitively expensive wouldn't be negligent, because that would be excessive. It would be disproportionate to provide very, very expensive equipment, and it would just drive some things out of business. Some activities would just become impossible. Okay, so Latimer against AEC 1953. There was a torrential downpour. The defendant's factory was inundated, and the water was mixed with this oily liquid on the floor, which made people liable to slip and fall over. Sawdust was spread over most of the floor, but there was a patch where it wasn't put, and the workman slipped on that part of the floor which hadn't been covered in sawdust. The trial judge found the defendant was liable because he hadn't closed the factory down. If you're not careful enough, if you're not prudent enough to cover the entire floor surface with sawdust, you don't have enough sawdust, then you must shut it down. It was easy to obviate the risk, and he hadn't taken those reasonable steps. Okay. Let me see. Sorry, 1 second. The House of Lords then said, no, they're not liable because he acted as a reasonable employer, that obviating all the risk would have been excessive. So let's look at urgent situations. So how important or urgent is the situation? The defendant might be in a situation where he or she can't think straight, act carefully, just doesn't have time to obviate all risk. And we have to be proportional. There are too many demands on resources. So we have to balance this against the goal which people are trying to accomplish. And if this is important enough, it might mean that it's justificatory of an unusual risk being undertaken. In Watt against Hertfordshire County Council, a fireman was called out because a woman was trapped under a truck. There was a heavy lifting jack that was needed urgently. Time was a critical factor. And the vehicle that was supposed to carry the jack was not to be found. Therefore, they loaded it onto another lorry which didn't secure it properly. And on the way to the accident, in their rushing to save this woman's life, the lorry had to brake, and the fireman was injured because the jack slipped and hit him. In such like circumstances, the Court of Appeal found the fire authorities had not been negligent. They were striving to save this woman's life. They had to cut a few corners, and they'd taken a risk. Lord Denning said that if the accident had happened in a business without an emergency, the plaintiff would have won. But he said the commercial end to make profit is very different from the human end to save life or limb. Close quotation. By end, they mean goal. If your goal is making money, that's different. You can't take such a risk. If your goal is to save someone's life, yeah, we can take risks with a view to saving somebody's life. So let's look at some statutory provisions. There's an emergence for compensation culture pursuant to the Compensation Act 2006. Section 1 of the Act deals with the deterrent effect of possible liability, and it says, a court considering a claim in negligence for breach of statutory duty may, in determining whether the defendant should have taken particular steps to meet a standard of care, whether by taking precautions against a risk or otherwise, have regard to whether the requirement to take those steps might A. prevent a desirable activity from being undertaken at all, to a particular extent or in a particular way, or B. discourage persons from undertaking functions in connection with a desirable activity. Close quotation. So we don't want this to lead to people to being over-cautious and good activity, sports, being stopped or just not done properly because we're just unduly, unnecessarily circumspect. Cautious when there's no need to be cautious. So the Act was there to deal with this misconception of compensation culture, but senior courts had already been saying they were worried about this deterrent effect of a liability, preventing people doing worthwhile activities. So I'm not sure what Section 1 is in addition to this. I think compensation culture is real, but is perhaps not as onerous or horrific as some of the most inflated reports suggest. So in deciding negligence claims, the Social Action Responsibility and Heroism Act 2015 says that judges must consider factors such as whether the alleged tort took place and the defendant was acting for the benefit of society. And if it was, then there should be no liability. If the defendant was acting heroically by intervening in an emergency, this statute is seen by some to be just obsolescent, a nonsense. Well, which is an awful pity of the judiciary disregarding Parliament. Toodaloo.